still with me, and criminal defense attorney Mark O'Mara and attorney Richard St. Paul. Thank you both for joining me tonight, gentlemen. We'll start with you, Mark O'Mara, about the prosecution's opening statement here. Motive means opportunity, clearly the theme for Miss Whaley here, but really she had to tediously piece together a very complicated story. How do you think she did?
I think she did a pretty good job. It was a little rote or, standard. You have to get out and deal with motive because obviously that's one of the concerns or maybe weaknesses of the Commonwealth's case. So she sort of took that on and said, look, I'm going to talk to you about motive because it's not necessarily or readily apparent. And I think the reason why she has to start stitching her case together, if you look at it that way, is there is mostly and only circumstantial evidence to try and tie the two together in this case, or try the defendant to the crime. I'm very concerned, quite honestly, about the admissibility of that bullet and the dog tag some 4 or 5 months afterwards. That's surprising, concerning, and I would imagine it's going to be a real point of the defense to say, how does everyone miss this? How did all of them miss it for 4 or 5 months? The two critical pieces of evidence that, lo and behold, tie the defendant to a case that he otherwise was not really tied to. So again, I thought her opening was good, fairly straightforward, accepting her responsibility. This case, I think, as we go through it, is going to be a quote reasonable doubt case. The state's Commonwealth's going to have a difficult time convincing this jury to put together all the pieces to do away with all the reasonable doubt that I presume the defense is going to throw at them.
Oh, for sure. And Richard St. Paul, I want to get your take also on this. And Mark brings up a good point about that 5-month delay after authorities searched that home intensely, did not come across the shell casing. All of a sudden it's found by the family. That's a lot of fodder for this defense.
Oh, no, absolutely. And just look at it. It is a lot of circumstantial evidence that has to be all tied in. It was interesting, right? So the prosecution will always tell you that, they don't have to prove motive. But a lot of times, in order to sell it to the jury so that they can get a conviction, they talk about motive. And here, the motive is extremely important. Without that motive, none of this makes any particular sense, right? The other thing is, it's a shell casing, right? So it's not where you have the forensic of whether or not the bullet was fired from the particular gun. It's a shell casing. And so presumably all 45 have that particular shell casing. What's more important is the bullets that were found, that matched the gun that was in Mr. Martin's safe. Was more key. And with that missing, I think the defense has a better time in terms of showing reasonable doubt. And I think it's an uphill battle if it's just only a shell casing and no other forensic evidence to tie Mr. Martin to the murders. That's an uphill battle for the prosecution.
Richard, you bring up a great point, actually, because in the defense opening, the attorney talks about how the bullets in the bodies don't match that shell casing. Let's listen.
We're going to put some evidence on from this witness stand as well. We don't have to. Judge told you we don't have to. We're going to. And you know what some of that evidence is going to show? Not the shell casing, right? Because the shell casing is the smoke and mirrors. What matters are the actual bullets, the projectiles that struck these poor people. And those don't match the gun.
So Mark O'Mara, to Richard's point, shell casing, smoke and mirrors?
Well, it's a great way to present to the jury because let's face it, why don't they match? And why, if you don't have ballistics, how does that weaken the Commonwealth's case? And the other argument is, and I'm sure it's going to come up in argument or presented through maybe some of the cop witnesses or law enforcement witnesses, is, so when was the last time that you really noticed that somebody who thought this out, intelligent guy, pilot, would actually just hold on to a murder weapon that he doesn't need to hold on to? So, there's a lot that the prosecution is going to have to look at and try to say, ignore the extraneous. Let's just focus on the fact that he may have had a grudge, he may have had opportunity, and we have 3 dead people, so we should find somebody guilty, and he's the guy on the other side of the V. And unless they can cobble together a lot more than the suggestions, then I imagine the defense attorney is, again, just going to look at this and go, how can you possibly be convinced beyond a reasonable doubt of anything in here? They've even charged them with the suggestion that somebody else who they don't know has done it. So again, as was just said, uphill for the prosecution at this point.
Great thoughts from Mark O'Mara and Richard St. Paul. I appreciate you both for being with me, hanging out with me tonight. We're going to keep going because coming up, Robert Durst housekeeper testifies today and reveals the suspicious stain she came across after Kathy Durst disappeared. Then the defense tries to diminish her suspicions in front of the jury today. Did it work? That's next on Court TV. Welcome back to Court TV Live. I'm Chanley Painter, and we are in the third week of California versus Robert Durst. Prosecutors want to prove that Kathy Durst's disappearance triggered a chain of events that would cost Durst's neighbor and ultimately Durst's best friend Susan Berman their lives. Earlier today, as the 78-year-old real estate heir sat at the defense table in his wheelchair, he watched his house cleaner from decades ago testify for the state. Elizabeth Jones began working for the Durst at their South Salem weekend home at age 23, 2 years before Kathy Durst vanished. In the weeks after she went missing, Jones observed several suspicious things around the house.
Had you already made some observations regarding the condition of the house that were different?
No.
Did you make some observations at or near that time?
Yes.
And can you describe what you saw about the house at that time that was different than how it usually was?
There was something on the dishwasher.
When you say something on the
It
dishwasher,
looked like blood.
I'm sorry?
It looked like blood.
And I want to ask you, is that something that appeared to you to be recent or fresh?
Yes.
And I want to ask you, are you aware of that it appeared recent or fresh? Because that would be something you cleaned every week.
Right. That's correct.
And so if the, what looked like blood on the dishwasher had been there previously, when you had cleaned the week before, would that have been something you would have noticed?
Yes.
So this was a new observation.
Yes.
So you said that you saw these dark colored, what looked like blood on the dishwasher. Anything else that you saw?
Yes. In the dining room, I didn't know there was hidden panels above a closet. And I noticed fingerprints on them. And the panels were
And
out.
these panels, did you know previous to that they were there and what they were?
No, I didn't know they were there.
So in looking at them, you were able to see that there were hidden panels that you were unaware of because of how they were attached. They looked as if they'd been opened.
Yes.
This is leading, Your Honor. Object to leading.
Foundation, this is
Object to suggesting that.
Foundation as a prior statement she's previously given.
No. Preliminary matters are appropriate to that. And so overall.
So in other words, your statements about the dishwasher and about the observations you're about to give in a moment are things that you discussed, correct, back in 2000 with the New York State Police?
That's correct.
All right, so was there anything else that you noticed besides what looked like a blood stain on the dishwasher and the hidden cabinet being open? Anything else you observed?
At the time that the state troopers were there?
Either at that time or shortly thereafter. I'm referring specifically to toilet paper.
Yes, that was another time. I came in another day to clean, and the front hall had hundreds of rolls of toilet paper.
And let me ask you, was that before the state police had come to alert you about Kathy?
No, that was after.
And at the time, did you have any idea this toilet paper that you saw, what it was from?
No, I did not.
And can you describe specifically what did you see with respect to the toilet paper?
It was bags and bags of toilet paper
And
throughout the front hall.
how many bags?
100, 50.
Had you ever seen toilet paper
No,
like that before?
no. And then the following week, it wasn't there.
And When you saw the toilet paper, did you see anything else with respect to whether there had been any cleanup efforts?
No, I did not.
So you see the toilet paper. Did you ask Bob Durst about it?
No, I did not.
How come?
I never would see him. He was only there on the weekends.
Troopers showed up at the house. Did they have a team of like CSI people with them where they went through the house and like you see on TV with a big team of people that are going through and analyzing things?
No, they just came in, looked at what I showed them, and then they left.
And based on their response to you, did they appear to be very interested in what they had seen?
That calls for conclusion, speculation.
You may answer.
Could you repeat the question?
Did the troopers who came in and took the actions that you've said with respect to what they looked at, did they seem very interested in what they had found, what you showed them?
No, I would say no, they didn't seem interested.
And do you recall, if I were to ask you, how long do you think they took to make these observations?
I would say they couldn't have been there more than 5 minutes.
Did they conduct any interview with you?
No, they did not.
So then Robert Durst's attorney cross-examined Jones and tried to minimize what she saw.
At 23 years old, you saw a stain, and you thought it looked like blood, right?
Yes,
But you showed it to the troopers,
that's correct.
and they didn't take a sample of it.
No, they did not.
Did that indicate to you that they didn't think it was blood?
That's correct.
All right. To set this scene, these troopers knock on the door and they show you an article from the newspaper, headlines about a reward being offered, right?
Yes,
And you invite them in and show them the two things that you have testified about this to this jury. First, the stains that their reaction indicated they didn't think it was blood. And second, the panel that you saw in the dining room, did you say?
that's correct.
Okay. And they looked at that.
Well, they had to climb up on a ladder to look at it.
They climbed up on a ladder.
That's correct.
Where was this panel?
It was above a closet
In the
in the
dining room.
dining room.
All right. So these troopers, did you get the ladder for them?
It was right there.
Well, where was the ladder?
It was a chair that you would flip and it would turn into a ladder that you could reach up there.
Okay, one of these kind of kitchen stool ladder things that is a stool, or you can take some steps out of it, step up on.
It was nicer than that, but that's what it was.
It wasn't like a carpenter's ladder where you.
No.
It
It
was
looked like a piece of furniture and then you would turn it, it would become a ladder.
a piece of furniture that you could use to step up to, if you had to, for instance, reach a light bulb or something above your ordinary reach.
That's correct.
And the police looked at that.
Yes, they did.
Did they take it with them?
No.
Still with me, criminal defense attorney Mark O'Mara and trial attorney Richard St. Paul. Let's talk about this testimony. Mark O'Mara, so alleged blood in the kitchen, some fingerprints on the panel, all apparently overlooked by those troopers walking through the home after Kathy disappeared.
Well, it's always interesting and difficult when a prosecutor has to sort of attack or undermine any law enforcement investigation because, they're always on the same side. So first you have the prosecutor sort of saying, well,